Convener, I'll turn to your question just in a second, but as we've agreed, I'm required to explain to those watching the proceedings and on legal advice to read out a short legal statement. I am severely hampered in making this evidence by two constraints placed upon me by the Crown Office. First, in relation to an order placed under Section 11 of the Contempt of Court Act 1981, members will be aware of the unwarranted intervention of the Crown Office to ensure redaction of key passages from my evidence as they relate to meetings in March and April 2018, which have a direct bearing on the events being examined by this committee. The evidence will not now be heard fully today in this Parliament, despite being freely available online and elsewhere. In my estimation, it's very damaging to the work of this committee and to a public seeking answers. It is an intervention which has drawn widespread criticism, including, I note this morning, from Lord Hope, the former President of our Court of Session. Secondly, in relation to the further blocking of evidence from this committee, I would draw attention of the committee to the decision of the Crown Office to prevent disclosure of evidence demonstrating the conduct of key individuals in this inquiry under reference to Section 162 of the Criminal Justice and Licensing Act Scotland 2010. This provision, and I know this because I was First Minister when it was introduced, was not passed by the Parliament to prevent a parliamentary inquiry getting to the truth on matters of the utmost public interest. It's being misused in its current context, and the application of these provisions and the threat of prosecution excuse me, the application of these provisions and the threat of prosecution made me, if I offer that evidence, is in my estimation both extraordinary and unwarranted.